One bad news from Madras High Court, Honorable Madras High Court, pertaining to unqualified consultants. Unqualified consultant. Due to the mistake done by the consultant, the reply was filed, irrelevant reply was filed. Shokha notice dated 22/5/2024, but for which an irrelevant reply was filed by the dealer because as per the advice of the consultant. So, this is before the Honorable High Court for proper relief because of the irrelevant reply, the assessing authority has raised the demand and freezed the bank account and coercive action, etc., etc. Now, the dealer approached the court and surrendered that due to the ill advice given by the consultant, wrong reply was filed. Based on that wrong reply, irrelevant reply, demand was raised. Now, the Honorable Madras High Court commented very harshly, in a harsh manner, and the findings of the court is as follows. This court feels that this type of wrong advice given by an unqualified person cannot be accepted. This is the crucial issue. And further, the Honorable Court directed the department, respondent department, is directed to issue notice or circular, note or circular to the assessees to engage consultants and get advice from a qualified consultants. So here also the court commented unqualified consultant and qualified consultant. So directed the CD department or JC department to issue a note or circular to assessees by advising to engage a consultant and get advice from a qualified consultants. Otherwise, the assessee file petitions directly to employees or renters. The ill advice given by the unqualified consultant would generally be on account of work burden in which they are used to advise very many clients. Generally, consultants will handle 25 to 50 or 50 to 100 as per their market demand. Sometimes consultants may handle the case of 200 to 50 also. Because of the work burden, the unqualified consultants may give the ill advice to the many clients. Because this type of cases frequently Madras High Court watching or observing many cases were filed because of the ill advice given by the consultants. So finally, the Honorable Court directed the respondent department to come with a clear note or circular advising the assessees to engage only qualified consultants. Further, the Honorable High Court held that as and when the assessees approach these type of consultants, in order to ensure that assist does not go out of their hands, the unqualified consultants violate the acts. This is very unfortunate on the part of unqualified consultant. So these are all the aspects that would come across before the notice of this court while handling various cases. So this is not the first case. The court while handling the many cases in various occasions, they come across this type of ill advices given by the consultant. Therefore, the department is directed to come with a proper circular to the assist in respect of engagement of a qualified consultant. Finally, it is the responsibility of the department now, as per the directions of the Honorable High Court, to give some proper note or circular for engaging of a qualified consultant. But in my opinion, in the rural areas, it may not be possible. In cities and major towns, clients may get the qualified consultant, but in a offshore areas or rural areas, this is not possible. And generally, we know very well that RMPs are handling many cases in the rural areas rather than MBBS doctors or MDs because of the belief of the people on the RMPs. Generally, they prefer RMPs only for first stage. Like this, in our field also, generally in rural areas or remote areas, clients are depending on the unqualified consultants only. Some occasions it will misfire. So finally, Honorable High Court gave direction to the department come with a proper circular. Very unfortunate thing. Hope our consultants also in henceforth or in future, do not make any such kind of mistakes, and hope they will give a proper advice to the clients. Thank you. Kindly subscribe if you are watching first time in my channel. Kindly subscribe and forward to the need. Thank you. Thank you very much. The citation is in the case of Chandrasekharan, proprietor Subha and Thomas versus Assistant Commissioner. The land judge is Justice Krishnan Ramaswamy. Judgment dated 19/8/2025 from the Honorable Madras High Court. Kindly go through and frame your own opinion. Thank you.